This video will provide a brief explanation about American constitutional history and issues relating to racial discrimination. Obviously, this is a very big subject, and this video will just be giving you a quick, basic overview. The U.S. Constitution originally did not provide any protection against racial discrimination. In fact, it was quite the opposite. Although the Constitution avoided the use of the word slavery or slave, it was based on the assumption that slavery would continue to exist, at least in large portions of the United States. For example, the Constitution contained a provision that essentially prevented Congress from prohibiting the importation of slaves until the year 1808. So, in other words, the Constitution guaranteed that states could continue to allow the importation of enslaved people for 20 years. The Constitution also contained a clause promising that fugitive slaves who escaped into another state would not become free and would be returned to slave owners. And the Constitution's 3/5 clause provided that an enslaved person would be counted as 3/5 of a free individual for purposes of determining each state's congressional representation. In the first decades of the 1800s, slavery became a highly controversial issue. The country was increasingly at odds over it. The issue eventually reached the U.S. Supreme Court in the case of Dred Scott versus Sanford in 1857. Dred Scott was an enslaved person in Missouri where slavery was legal. Dred Scott's owner was a doctor in the U.S. Army. The doctor was stationed for several years at Army forts in the state of Illinois and then in what is now the state of Minnesota. Slavery was prohibited in those places. After returning to Missouri, Dred Scott brought lawsuits seeking to establish that he had become a free person as a result of living in those places where slavery was prohibited. The Supreme Court ruled against Dred Scott. They decided that he was still a slave, but they went well beyond that and broadly declared that it was impossible for a person of African descent to be an American citizen. In other words, they declared that all people of African ancestry in the United States are not citizens and had no constitutional rights. This applied to all enslaved people, but also those who were descendants of slaves but had obtained their freedom. The Supreme Court thought the decision would help to end the national conflict over slavery by transforming it into something that was a legal issue that had been resolved, rather than leaving it to continue as a political issue. But the Dred Scott decision did not have that effect at all. Supporters of slavery loved the decision, and opponents of slavery said that it was evil and totally illegitimate. Anger about the decision helped to push a relatively new political party, the Republican Party, to nominate Abraham Lincoln as a candidate for president in 1860. Lincoln won the election, and when he became president, Southern states seceded and attempted to form a new country, and the American Civil War was soon underway. During the war, Abraham Lincoln issued the Emancipation Proclamation. It declared that slavery was no longer valid in those places that were still in rebellion and under Confederate control. It did not apply to places like Missouri that were slave states but had not attempted to secede. The Emancipation Proclamation thus did not free all American slaves, but it was a significant step toward the elimination of slavery. The United States military eventually prevailed and the Civil War came to an end. In the aftermath of the war, the United States added 3 important new amendments to the Constitution. The 13th Amendment provided that slavery and involuntary servitude would no longer exist in the United States. The 14th Amendment had a number of provisions, but its overall purpose was to address racial discrimination and give rights to the formerly enslaved people. The amendment overruled the Dred Scott decision by making it clear that people of African ancestry could be American citizens. And it said that all persons in the United States are entitled to the basic constitutional protections. They are entitled to equal protection of the laws. They are entitled to due process if the government is going to take away their life, their liberty, or their property. And they're entitled to all of the privileges and immunities of American citizens. Privileges and immunities is just a fancy, old-fashioned term for rights. And finally, the 15th Amendment prohibited racial discrimination with respect to voting, so it guaranteed that citizens of all races would be entitled to vote. These amendments purported to do away with racial discrimination, but obviously they did not have that effect. Racial discrimination continued in many ways. That was in part because the constitutional rights that people were supposed to have were simply ignored. For example, the Constitution now prohibited racial discrimination with respect to voting, but in many places that constitutional right was simply disregarded. But the effectiveness of the new amendments was also undercut by the way in which they were interpreted by the Supreme Court. The court made a number of decisions that limited the effectiveness of the new constitutional rights. For example, the Supreme Court decided a set of cases in 1883 that were known as the civil rights cases. These cases were about the validity of federal statutes that prohibited racial segregation of private business facilities, like theaters, hotels, and railroads. So, Congress was attempting to stop racial segregation, but the Supreme Court struck this down. The court said that the 14th Amendment applies only to state action, meaning actions of a state or local government. So if a state or city or county was discriminating, the 14th Amendment would apply to that. But it did not apply at all to private acts of discrimination, such as by a private company or a private individual. So given that decision, you might think, well, at least that means there would be no more racial segregation required by state or local laws. That would clearly involve state action. But the Supreme Court also held in Plessy v. Ferguson that racial segregation was okay. They said that the 14th Amendment gives people the right to equal protection of the laws, but that merely means they would be treated equally, not that they would be integrated together. In other words, the Supreme Court accepted the idea that separate but equal was a satisfactory way of giving people equal protection of the laws. They would be segregated by race, but in a way that was separate but equal. So, the promise of the 13th and 14th and 15th Amendments was not fulfilled. The Supreme Court interpreted the amendments in ways that limited their effectiveness, and racial discrimination continued in many forms. But the new amendments were not completely useless. There were cases in which the Supreme Court did strike down some types of racial discrimination. For example, in a case called Yickwo v. Hopkins, the Supreme Court said that it was unconstitutional to apply a licensing system for laundry businesses in a way that discriminated against Chinese people. In a case called Strouder v. West Virginia, the Supreme Court said it was unconstitutional for a state to categorically bar all black people from serving on juries. And in Buchanan v. Warley, the Supreme Court said it was unconstitutional for a city ordinance to prohibit the sale of property to black people in neighborhoods that were predominantly white. So, there were some cases in which courts found that racially discriminatory practices were unconstitutional, but simultaneously there were many ways in which racial discrimination continued to occur. Eventually, there were more and more legal challenges to racial discrimination that were being asserted. This was in part because there was an organization, the NAACP, that had a legal advocacy program that initiated and supported these kinds of cases. The legal strategy was incremental in nature. In other words, they didn't try to challenge all forms of racial discrimination across the board right from the start. Instead, they tried to start small and bring the kinds of cases that seemed like they had the best chance of success. And they tried to win some small victories and then build on those cases and try to go further. For example, with respect to segregation of schools, they did not immediately challenge segregation at the elementary and secondary school levels. Instead, they started out with much narrower challenges focused on graduate and professional education. And in these initial cases, they accepted the premise of separate but equal. They said, okay, let's assume for the sake of argument that separate but equal is what the Constitution requires. That does mean that it needs to be equal. And they would bring lawsuits about situations that did not seem equal. For example, they brought a lawsuit saying that the state of Missouri had a public university with a law school for white students, but there was no law school for black students. The state said, well, if there are black students who want to go to law school, we'll arrange for them to go to law school in other states. The challengers said that's not equal, so it doesn't satisfy the separate but equal rule. And the Supreme Court agreed. They said you need to provide something that is separate but equal, and telling you to go to school in some other state is not equal. So the civil rights attorneys gradually won some cases like that. They also challenged discrimination in contexts other than education. For example, in Shelley versus Kramer, the Supreme Court held that enforcement of racially restrictive covenants violates equal protection. It was a common practice for neighborhoods to have these kinds of restrictions, which prevented houses from being sold to people of color. The Shelley case was about a house in St. Louis, and Missouri courts had held that a covenant preventing the sale of the house to a black person was valid because it was purely a private matter. The covenant was a provision in a private contract between private parties about the sale of private property. But the Supreme Court disagreed, concluding that when a court gets involved to enforce one of these covenants, that is government action, and it's no longer just a private matter. Eventually, the NAACP and other civil rights lawyers brought broader claims. They challenged the racial segregation of public schools at the lower grade levels, like elementary and high schools, and they argued that separate but equal was no longer sufficient to satisfy the Constitution's equal protection requirements. In Brown v. Board of Education, the Supreme Court unanimously agreed. The court held that segregating students by race was inherently unequal, and they relied on social science research which showed that racial segregation had detrimental effects on children. Brown was followed by more decisions that applied the same principle to other settings and declared that it is unconstitutional to have racial segregation of other public facilities, like parks and swimming pools and golf courses. But of course, fully implementing these decisions was not easy. There was a great deal of resistance to the Supreme Court's decisions, and it took years for courts to implement desegregation decrees. So that brings us up to the modern era in our story, and now let's quickly review the constitutional provisions that apply to issues about racial discrimination. There is the 13th Amendment. It prohibits slavery and involuntary servitude. And that may make it seem like it's a provision that served its purpose a long time ago and no longer has relevance. But there are issues today that involve forms of slavery or involuntary servitude, such as some situations involving human trafficking. And in addition, the Supreme Court has held that the 13th Amendment empowers Congress to take actions that go beyond just addressing slavery and involuntary servitude. The court has held that the 13th Amendment also gives Congress the power to address things that are badges or incidents of slavery. A badge or incident of slavery would be something that is a lingering consequence or a vestige of slavery. In particular, the Supreme Court used the 13th Amendment to uphold a federal law that prohibited racial discrimination in the sale or rental of property. The case, Jones v. Alfred H. Mayer Company, was about a new housing development near St. Louis, where the real estate developer had a policy of selling homes to white people only. The Supreme Court held that Congress had the power, under the 13th Amendment, to prohibit such practices. When slavery ended, one of the rights that would have been crucial for the formerly enslaved people was being able to buy and sell property. And so, racially discriminatory practices in the housing market were a badge or incident of slavery that Congress had the power to eradicate through legislation. One of the distinctive features of the 13th Amendment is that it applies to everyone, not just governments. Most constitutional rights apply only to governments and can be violated only by government actions. But the 13th Amendment simply declares that slavery and involuntary servitude shall no longer exist in the United States. And that means they are prohibited completely, no matter who is imposing them, whether it involves government or purely private actions. This makes the 13th Amendment an important source of power for Congress, because it enables Congress to go after racial discrimination that is perpetrated by private actors, whether it's discrimination by private companies in the housing market, or discrimination by private schools, or racist hate crimes committed by private individuals. There is also the 14th Amendment. Again, it guarantees several rights, but when it comes to racial discrimination, the most important one is the promise that all people will receive equal protection of the laws. Technically, the 14th Amendment applies only to state and local governments, but equal protection rights apply to the federal government as well through the Fifth Amendment's Due Process Clause. But again, that's a sort of technicality, and the crucial thing is that all levels of government are required to respect equal protection rights. And this means that if the government is doing something that is intended to treat people differently on the basis of their race, the government must have a very strong reason for doing so. Courts apply a test that is known as strict scrutiny, which means that when the government treats people differently because of race, the government must show that its action is narrowly tailored to serve a compelling government interest. This is a very demanding standard, which puts a heavy burden on the government to justify any action that distinguishes between people on the basis of race. There is also the 15th Amendment, which prohibits racial discrimination when it comes to voting and elections. So, those are the major constitutional provisions relating to racial discrimination. But it's important to remember that the Constitution is only one source of law. There are other types of laws that also address racial discrimination. For instance, there are federal statutes that prohibit certain types of discrimination. For example, the Civil Rights Act of 1964, where Congress prohibited racial discrimination by businesses. That statute is why businesses like restaurants and hotels are no longer segregated, and it's why employers cannot engage in racial discrimination in hiring and paying their workers. The Civil Rights Act was an important exercise of Congress's power to regulate interstate commerce. There are also civil rights and anti-discrimination laws of various kinds at the state and local level. By enacting such laws, legislatures can go beyond what the Constitution itself covers. Whether it's Congress or a state legislature or a city council, they can prohibit practices that are discriminatory but do not necessarily violate constitutional rights. Racial discrimination obviously is still a significant issue, and there are important questions about the constitutional provisions on this that continue to be debated. One of those issues is about the extent to which constitutional rights can be violated by government actions that have a racially discriminatory impact, but were not intended to be racially discriminatory. The Supreme Court has held that equal protection rights are violated only when the government intentionally discriminates on the basis of race. If a government's action does not have a discriminatory purpose or intent, then it's okay, even if it clearly has a discriminatory impact or effect. For example, one of the cases about this was Village of Arlington Heights, which was about a suburb that had a zoning ordinance that prohibited the construction of multifamily housing facilities, such as apartment buildings. The Supreme Court said that even if this clearly had the effect of limiting the socioeconomic and racial diversity in that area, it would not be unconstitutional unless it was intended to be racially discriminatory. Or to take another example, if a law requires racial segregation of schools, that is unconstitutional. But if you wind up with some schools being overwhelmingly white and some being overwhelmingly black, because of the fact that there are deeply entrenched patterns of racial segregation in terms of where people live, that is not a constitutional violation. This means that the Constitution addresses explicit, intentional forms of discrimination, but not implicit or systemic ones. In recent years, there has been a lot of attention paid to implicit forms of bias and to systemic forms of discrimination. And some people have called for the Supreme Court to reconsider its thinking about unintentional forms of discrimination. Affirmative action is another issue that remains controversial. What if the government treats people differently on the basis of race, but they do this in order to help remedy the effects of past discrimination? For example, what if a public university takes race into account in admitting students in order to try to have more racial diversity among its students. The Supreme Court has held that this is okay. They have held that strict scrutiny applies, so the government would need to have strong justifications for its affirmative action policies, but they can be valid and constitutional. But the court has held that affirmative action policies must be carefully limited and not taken further than is really necessary, and they should not be permanent. In one of the Supreme Court's cases about this, back in 2003, the court predicted that in 25 years there would be sufficient progress made so that racial diversity in university admissions would no longer be necessary. The Supreme Court is not necessarily bound by that 25-year time limit, but it's noteworthy that the 25 years will be up in the year 2028, which is not too far away. And as a result of changes in the membership of the Supreme Court, it is very possible that affirmative action policies may be held unconstitutional even before 2028 arrives. Some members of the Supreme Court have argued that affirmative action policies are an unconstitutional form of discrimination, and there is a good chance that a majority of the justices on the Supreme Court currently hold this view. So, these are some examples of how the rules of constitutional law concerning racial discrimination are not something that is set in stone. They have evolved over time and will continue to do so.